Hi, I'm Carol Bertsch. I'm an elder law attorney in San Antonio, and we're here today to talk about who decides if you can't. Advanced directives. We're going to talk about what they are, what they do, and who needs one, as well as what happens if you don't have one. Advanced directive is really an umbrella term for 4 separate documents. Your medical power of attorney, which is sometimes called a healthcare proxy or a medical proxy. Your directive to physicians, family, and surrogates. In Texas, that's what we call it. A lot of folks elsewhere call it a living will. We like to make names longer and more difficult here in Texas. A third document is the out-of-hospital do not resuscitate order. And that document also may have a different name in other states. We usually refer to it as abbreviated DNR. The last document is a HIPAA authorization. And that's another document that other states might not use, but we use here in Texas. So what's a medical power of attorney? It's just a document that lets you name a person to make health care decisions for you if you can't. The person who you appoint is called your agent. The medical power of attorney becomes effective only when your doctor says you can't understand and make decisions for yourself. Until that time, no one gets to make decisions for you. So don't ever let someone say, you appointed me your agent, I don't agree with what you're doing, and I'm going to override you. No, as long as you have capacity, no one can tell you what decision to make. Not the medical providers, not your doctor, not your family. Only when the doctor has determined that you can't understand your situation does the medical power of attorney become effective. Your directive to physicians allows you to tell the world what kind of care you would want if you were terminally ill or in an irreversible condition. But remember that this document, again, only comes into play if you're incapacitated. If the doctor, you go to the doctor and the doc says, look, you've got terminal lung cancer. Do you want treatment? And you had, or we don't even know if it's terminal, but we think it's going to be, do you want treatment just to see what we can do? And you had earlier done your directive to physicians that said no life-sustaining treatment. Doesn't matter. You've got capacity. That means that you get to make the decision for yourself at that time. Only if you are so sick that you become incapacitated, you are too sick to understand what's going on, only then does your directive to physicians become effective. Terminal means it's an incurable condition that they think is going to produce death within 6 months, even if we used life-sustaining treatment. Irreversible is a condition that can be treated but never cured, is fatal without life-sustaining treatment. So your directive to physicians only applies if you're in a terminal condition or an irreversible condition. That's a big difference between your medical power of attorney and your directive. Your medical power of attorney is the document that says, if I've been in a car accident and we have to decide whether to amputate my leg or not, the medical agent decides that because you're not in a terminal condition and you're not in an irreversible condition. Here in Texas, we need both documents because they apply in different situations. Your DNR is a completely different kind of document. First, it's a doctor's order, so the doctor has to sign it. You can't come to me and have me do a DNR for you. You can't download it off the internet and sign it and have it be effective. It's a doctor's order and a doctor has to sign it. You don't have to be terminally ill to use a DNR. You can use a DNR or someone can do one for you, like your medical agent, if you have Alzheimer's disease and you've gotten to the point where if your heart did stop, you really wouldn't have wanted the EMS to restart it. If you're in that situation, your medical agent and your physician sign the do not resuscitate order. Now, it's very important to understand the difference between the do not resuscitate order and the directive to physicians. The directive to physicians is a document you can do today because it applies in the future when you're incapacitated and you have either a terminal or irreversible condition. Your do not resuscitate order applies today, so that if your heart stops and you have that DNR, EMS is not going to restart your heart. So, for example, if I fall over right now, I don't have a DNR. I want folks to call EMS to resuscitate me because I don't have any life-limiting illnesses. I'm not terminal. I'm not irreversible. And I think there's a good chance that I can come back. Now, let's say that my heart stops, I have a massive heart attack, and these folks here, they say, we'll call EMS, and EMS finally comes 30 minutes later while I've been laying on the ground. At that point, they go ahead and resuscitate me because I don't have a DNR in place. But there's been so much brain damage because of lack of oxygen that when I get to the hospital, the doc tells my husband, you know, she's in an irreversible condition. She's in a coma. We don't think she's going to get out of it. And my husband, I hope, will wait a little while before he makes the decision to withdraw life support, withdraw the feeding tube, withdraw the breathing machine, based on my directive to physicians. So the difference is that the directive to physicians, I already have one, and I want to have one in place for future, if something happens in the future. But I don't want a DNR in place. When might you want a DNR in place and you're not irreversible and you're not terminal? Well, let's say that you are 95 years old. You've lived a good life. You're very happy with where you are, but you're pretty frail. You're not sick, but you're pretty frail. If you were in a car accident and your heart stopped, you wouldn't necessarily want EMS to come over and use the paddles and pound on you and get your heart to start again, because they're probably going to break some ribs, they're probably going to damage some internal organs, and you're going to be in a worse shape than if they had gone ahead and let you die. So if you were 95 years old, you might choose to have a do not resuscitate order in place. Again, I don't want a DNR in place because if they pound on my chest and break my ribs and internal organs, there's a good chance that I'm going to recover from that because I'm a lot younger and my body will heal more quickly. That's just the reality of our aging process. As we age, we don't heal as quickly and we don't recover as well. What about your HIPAA authorization? HIPAA stands for Health Insurance Portability and Accountability Act. And that was a very well-intentioned piece of legislation. But one part of it, it was intended to help preserve your privacy. And it does preserve your privacy more than you want it to even, because it means that medical providers are sometimes reluctant to disclose your information to someone you might want to have it, like a spouse, because of the criminal penalties involved if they violate HIPAA. With a HIPAA authorization, you're designating others to allow them to get medical information from medical providers. You're allowing the medical providers to disclose to them. The HIPAA authorization is a little bit different from the medical power of attorney. Remember that the medical power of attorney, number one, it's giving someone permission to make decisions for you. And number two, it only applies if you're incapacitated. The HIPAA authorization is saying, doctor, you can disclose information to this person, and it's effective even if you're not incapacitated. When might this be useful? Let's say that you have just undergone a procedure and you're woozy, and your spouse and family members want to know how you're doing. Or you've gone home from the procedure and now it looks like you're having some sort of adverse reaction, and your spouse is calling the doctor's office saying, look, this is happening, what should I do? You want to have that HIPAA authorization in place so the medical provider doesn't say, well, I'd like to tell you, but I can't because that's health information that's privileged and I can't share it with you. You have the HIPAA authorization that you provide to your medical person, and it says, medical provider, you can go ahead and disclose information to these persons. Okay? All right. Who needs advance directives? The answer is everyone. Everyone. It doesn't matter how old you are. You don't have to be 90 to need an advance directive. All of us need advance directives. Why? Well, we never know what's going to happen. The 4 people on your slide did not have advance directives. Now, I hope that if something happens to you and you haven't done advance directives, you don't end up at the U.S. Supreme Court, or your family doesn't end up at the U.S. Supreme Court like Nancy Cruzan's family did, fighting over whether it's all right to withdraw life-sustaining treatment. These 4 folks ended up in court, or their families did, I should say, out of that. But why are the 3 women who I've listed first, why are they significant? Because they were all in their 20s when they had a medical episode, a car accident, or some reaction in their body that left them incapacitated. In their 20s. Now, they never had thought about what kind of care they would want if they ended up in their situation. Lots of people haven't thought about it, and certainly 20-year-olds aren't going to think about that. They think they're indestructible. But they ended up in that situation, and there was conflict about what they would want. Would they want to continue living that way, or would they want to be let go? In Karen Ann Quinlan's case and Nancy Cruzan, the government said, we don't think that you should withdraw life-sustaining treatment, while the family said, we don't think our loved one would want to continue living this way. In Terry Schiavo's case, the most recent case, the family, the parents and siblings said, we think Terry would want to continue living like this, while the husband said, it's been going on for 13 years. She would not want to continue in this position where she's just laying in a bed, being cared for, unable to interact in basically a vegetative state. All 3 of them ended up in court. Now, in Hugh Finn's case, that was a man in his 40s. But again, he didn't have any documents, any advance directives. His wife said, Hugh wouldn't want to live this way. His family said, oh, yes, he would. This is something that he would hope he would come out of the persistent vegetative state. He would want to give himself that chance. And the courts had to decide in all of those cases. So it was taken out of the hands of the people that they loved and put in the hands of a court who didn't know them and had to make the decision based on evidence and what the law says. So all of this to say, just because you're 20 doesn't mean you don't need advance directives. And just because you're not 90 doesn't mean you don't need advance directives. We all need advance directives. Now, there is an important difference between the 3 documents, the HIPAA authorization, the medical power of attorney, and the directive to physicians, and the out-of-hospital do not resuscitate order. We don't all need an out-of-hospital do not resuscitate order. That's a document that applies in very specific situations. We do all need the other 3 documents. Well, what happens if you haven't taken my advice and you haven't gotten your medical power of attorney? We have something in Texas called the Consent to Medical Treatment Act. And it says that the health care provider can look to one of the following people in order of priority. So they can turn to your spouse. If your spouse isn't available or your spouse is deceased or you're not married, they can turn to an adult child, as long as that child has permission of the other children. They can turn to, if we can't get one child agreed on, they can turn to the majority of the reasonably available adult children. Let's say you don't have adult children, they can turn to your parents. If your parents aren't living, they can turn to your nearest living relative, or finally a member of the clergy. Let's say that you're telling me, Carol, I don't need a medical power of attorney because this is exactly the way that I would appoint the agent if I did have one. I would appoint my spouse first, then I would appoint my child. And I would go in order, and all my children would agree, they all get along, and everything will be just fine. Well, I'm here to tell you that sometimes parents have an unrealistic perception of how well their kids are going to get along when faced with that parent laying in a hospital bed with decisions to make. Okay? It's unfortunate, but lots of times, even kids who usually got along have differing views over what should happen and disagree over the right course of treatment. So even if you would have named your spouse first, what if you and your spouse were both in the same car accident? Then we have to go down to the children. Even if all of the children get along, are you sure you want to place them in this difficult situation where you haven't appointed one to make decisions and you haven't told them what your wishes are about medical decisions? You're going to tell me, Carol, they all know I don't want to be hooked up to a machine. Well, medical decision making is a little more nuanced than don't hook me up to a machine. We're going to talk about that in a minute. So even if they all get along and they're all going to make the right decision, they don't know what the right decision is without having talked to you about it, without you having told them what your values are. So what that means is you're putting them in a difficult position, in a painful position that they wouldn't have to otherwise be in. They're already upset. They're already grieving because here you are, very ill, very seriously injured. They are already feeling bad about that, and here you're adding on to it by not telling them ahead of time what kind of care you would want. What happens if you don't have a directive to physician? Well, we again go to the surrogate decision making. The healthcare provider looks to the spouse. It's a little bit different from the medical power of attorney. In this case, they turn to the spouse, next the reasonably available adult children, then the parents, then the nearest living relative. And again, the same concerns arise whether we want to have those children or that spouse suffering and grieving already, bearing the additional burden of trying to figure out what you would want. What happens if you don't have a do not resuscitate order? The law says that EMS must do everything they can to revive you and treat you. So if you have Alzheimer's and are incapacitated and there's not been a DNR put in place, your heart stops, they're going to restart it. That's their job. And I didn't address if you don't have a HIPAA authorization, but if there is no HIPAA authorization, medical providers can easily say, look, we can't share that information with you because HIPAA prohibits it. Remember that all of these documents can be revoked. That means that if you change your mind, if someone has gone all wacky on you and you don't want them making decisions anymore, you can change the documents. You can revoke and do a new one. Don't feel like, oh, I can't decide, I don't want to do this. Just decide, for now, if for this little bit of time, I'm going to say this person, and then I'm going to revoke this, and I'm going to give it to another person. You know, do one every year so the kids rotate. Okay, it's going to be you this year, you next year, you next year. And what I hope happens is that you never need to use those. I hope that you're never in a situation where someone else has to make medical decisions for you. But we know that that's not realistic for most of us. Most of us are going to end up in a situation where somebody else needs to make medical decisions. There's very few of us who live a long and healthy life and die in our sleep and never have to make never have to go to the hospital, never have the doctor make put forward difficult decisions for the family to make. Now let's talk about preparing advanced directives. The first thing you have to think about is who should be your agent. You need someone who's willing to speak out on your behalf if necessary. That means you're not going to appoint some shrieking violet. You're going to appoint someone who's strong and assertive, who will be your advocate. You need to appoint someone who's able to act on your wishes separately from what his values are or his own thoughts on what's the right thing to do. So if you're not able to have a discussion with someone to see if there is a compatibility between your wishes and the other person's, that's not the right person to appoint to make decisions for you. The best person to select doesn't have to be local, okay? It would be best if it's someone who could travel to be at your side, if necessary. But in today's world, we can go ahead and communicate via email, via fax, via the internet. So we can talk via the internet, over the phone, with Skype. We don't have to be present. So it's great if you can have someone who can come to your side, but it's not imperative. But going back to that other issue, we need someone who will talk to you about these sensitive issues. We need someone who is going to be willing to have these hard conversations. And we really want someone who's likely to be available into the future. We never know what's going to happen. That's why we always appoint a primary agent, a secondary, and even a third person, because we don't know what's going to happen. But ideally, if you're 90, you're not going to appoint your 93-year-old sister to be your medical agent, because the likelihood of her being able to take care of you and make decisions for you when your time comes are low. Now, after you've decided who the right person is, we need to think about what your values are. We need to think about what you would want to have happen. Now, this isn't fun. And I'm not here to tell you that you're going to enjoy this. I'm not being a merry ray of sunshine in your life at this moment. But it's something that we have to do because it'll make things easier for our loved ones if we've talked about if we've thought about and then talked about what we value. So I've included 2 worksheets for you that you can download and that will help you think about different situations. So one is, how do you weigh the odds of survival? And this is a very simple worksheet that asks, how much are you willing to endure for what chance, what probability of success? So if the probability that we were going to get you back to baseline was only 2%, how much discomfort, pain, inconvenience, just nausea, vomiting, any of those things, how much would you be willing to put up with? And what if the chance was that we couldn't get you back to baseline, but what we got you back to was someone who had 50% of the functioning that you have right now. Would you be willing to endure all of that if the chances of even reaching 50% were only 2%? Now, I know that sounds complicated, but do the worksheet, read it carefully. It's pretty clear. And social workers who might be viewing this for CEUs, I encourage you to do those documents yourself, because that's going to give you some insight into what your clients are going to be experiencing when you ask them to make these difficult decisions, have these thoughts, and talk about these things with their family members. The other worksheet is, are some conditions worse than death? Would you want treatment if you were in severe pain all the time? Would you want treatment if you were unable to recognize and interact with the people you loved because you were incapacitated? What kind of treatment would you want? Again, these are just worksheets to try to stimulate some thought so that you can think about what your values are, because the next thing you're going to do is communicate those values to your loved ones. All right, we're still preparing these advanced directives. We've thought about treatment issues. The next thing we're going to think about is quality of life. What's important to you about quality of life and what's not? For example, for me, it's very important to my quality of life to be able to interact with my loved ones. If I can't do that, I'm not so prone to want treatment. So when I'm preparing my advanced directives and when I'm communicating with my loved ones about that, they know that if she's so ill that she's not able to interact with us, and she's going to continue not to be able to interact with us, then she doesn't want treatment. They already know that ahead of time. When they're faced with that decision, when the physician puts that in front of them, they're not going to be scrambling. They're not going to be anguishing about, well, what would she want? I don't know. If I were in this position, what would I want? They're not going to be in that situation. I've taken that burden off their shoulders by thinking about it ahead of time, deciding what my values are, and then communicating it to them, to my loved ones. And by the way, it's very important. Your loved ones, your medical agent, is to make the decision that you would have made. They're not supposed to substitute their own judgment unless there's no way of knowing what you would have wanted. So they are supposed to follow your wishes. That's what a medical agent is supposed to do. And it's important to make sure that you've got someone appointed who understands that and is not going to say, well, you're making the wrong decision, and when the time comes, I'm going to do what I think is right. That's not an appropriate medical agent. And guardians, it's important for you to understand that when you're making medical decisions for your ward, you want to make the decision that you think they would make to the extent that they were able to understand, if they were able to understand, if they were in that situation now. So, for example, if you're the guardian of an 80-year-old, you want to make the decision, that person with a guardian of an 80-year-old with Alzheimer's, let's say, so they're incapacitated. You want to make the decision that when they had capacity, they would have wanted, the decision they would have made. If you're the guardian of a person with mental retardation, of course, they may have never been able to articulate what kind of wishes they want, so you just have to make the best decision in their best interest. Another issue in quality of life is thinking about being pain-free. A lot of folks are afraid of having to be in pain and living in pain. If that's an issue for you, you want to communicate that to your agent so that your agent knows when the physician says, now this is a painful condition and we're not going to be able to control that pain necessarily, even with all this treatment, your loved one knows, your agent knows, you know what, this is not a good place for the person who's appointed me. Now that you've thought about what you want, what your values are and your wishes are, it's time to do something really hard. And that is to talk to your agent and your family. Now, I say you not just talk to your agent, you've got to talk to your family. Why? Because if you just talk to your agent, and let's say that's oldest son. Now, do not appoint your oldest son just because he's the oldest son. You're going to appoint him because he's the one who you can have the conversation with. He's the one who can be an advocate for you. If that's not oldest son, you're not going to appoint him. If that is middle child, you're going to appoint middle child. And if none of your children can serve, can do that function for you, you're going to appoint someone else. You're going to appoint your sibling. You're going to appoint your best friend, because the person you appoint has to be willing to have the conversation with you, has to be willing to be your advocate, has to be willing to follow your wishes. But let's say you've chosen that person. We want the rest of the family to honor that person's position. We don't want them to hassle your agent and say, no, that's not what Mom would have wanted. Your agent knows what you would have wanted because you communicated that to her. Well, you've got to communicate it to everybody else who's going to be in that hospital room, because otherwise they're going to be saying, no, I know what Mom wanted. No, I know what Mom wanted. And your poor agent is going to be left not just with the grief of you being in a bad situation, not just with the pain of having to make decisions for you, weighty decisions, but also with the pain of having to fight with all of your loved ones. And that could mean creating a rift in relationships that are important to them. If you have one child who you've appointed and the other children disagree with that child, you're looking at perhaps ending up with you're gone, but that child's living on without the benefit of those relationships because of the damage that's been done to them. So you've got to talk to your whole family as well as your agent. And talking about it may even help you, as you talk about it and you think about it, may help you better decide what your wishes are. And it also, it may bring the family closer together. Maybe it won't. But you've got to do it. Well, you've thought about who you want to appoint. You've thought about your wishes. You've talked it through with all your family. What are you supposed to do next? You want to have completed your advanced directives. If you did take notes or do a worksheet, you want to keep that together with the directives, and you want them to be someplace where they can be found. You want folks to know where to go to get them. You want to give copies of your directives not only to your agent, but to your alternate agent and your second alternate. You want to give copies to your physician. Now, I know that in most cases, your physician is not someone who you've had a long-term relationship with who's going to sit down and talk to you about this. Nonetheless, go ahead, get it in the chart, just so you can have the conversation with the physician just a little bit, to make sure that physician is going to honor what your wishes are. If that physician is not compatible with your wishes, it's time to find a new physician. Of course, you're going to give copies, as I said, to everyone who's interested. Remember I said you can revoke these documents at any time? Well, once they're done, they're not just finished, put them in the drawer, you don't have to worry about them anymore. They're a work in progress. You're going to review them because your wishes, your values, what means quality of life to you may change. So here's a handy checklist. You're going to review them before each annual exam, if you have an annual exam, at the start of each decade of your life, after any major life change, and after any major medical change. You're going to go back and rethink and have those conversations again with your loved ones to reiterate what your wishes are. Your loved ones are going to be sick to death of you. Oh, we're having that conversation again. I don't want to. But it's important that you keep that at the top of their minds. Now, do you have to go to a lawyer to get these documents? You don't. You can pull them off of the Internet. Now, normally, I do not want you doing your legal documents off of the Internet. But these are statutory forms. They're going to be the same. They have to be substantially in the format that the legislature has promulgated, so you might as well just pull them down off the internet. And those are two websites. That slide lists two websites that you can go to. The TexasProbate.com does not have the documents up yet. It's still under construction, but caringinfo.org does have Texas documents. You want to do the documents that are appropriate for your state, because every state has different laws. You want to, if you move from one state to another, you want to make sure that you go back and do documents for the state you're living in now. If you're moving from one state to another and you don't have a chance yet to do your new documents, will the medical providers honor your previous documents from your old state? Well, they're supposed to. If it was validly done in your first state, Texas at least, and I believe all other states, is supposed to honor it. But the concern is, how can the medical provider know if it was validly done in the first state? So ideally, as soon as you get to your new state, you're going to redo those documents. Let's say that you're moving an incapacitated person from a state to live with you in your new state. We can't do new documents. That person doesn't have capacity to do new documents. Well, we're stuck with what we've got, and we'll just make the best of it. Now, there are some other websites that do have resources for you that I want to talk about, because I know that you're going to have difficulty, or you're likely to have difficulty, getting family members to talk about this. I know I've stressed it and stressed it. You've got to have your family members, you've got to communicate with your family members about this. They're going to say, "Oh, Mom, you're never going to get sick. You're not going to die." Well, you've got to stand firm. First of all, yes, you're going to die. It's going to happen. We don't get out of this life alive, so to speak. So we can't just let them get off the hook by saying you're never going to die. Yeah, we're going to acknowledge to them, this is hard. I don't like doing it. You can blame it on me. You can say, that mean old Carol Bertsch said I have to do it, and she was so scary, I feel like I must. You can blame it on other family members. You can blame it on situations that are happening in the news. You can say, I just read about that Terry Schiavo case, and I don't want that to happen to you. I don't want our family to be torn apart like that. There are other ways to approach it, and there are some resources out there that can help you with that. I'm just going to list them real fast. If you go to agingwithdignity.org, they have some handbooks to help you. That's agingwithdignity.org. You could also look at a booklet that's called Hard Choices for Loving People. And these are hard choices. They're hard to talk about, they're hard to think about, but we have to do it if we're responsible adults. And that website is hardchoices.com. You may have heard of something called 5 Wishes. That is a booklet that asks these same questions or similar questions. That's a great resource, but realize that it's not effective in all states. The purpose of the 5 choices is to help you articulate your wishes in a way that will stand for a directive to physicians or a medical power of attorney. Here in Texas, we have to have the specific forms that the legislature has promulgated. So do 5 wishes. Definitely fill it out, because it's another worksheet, another way to help you think about these issues. But don't stop there. You still need to do the actual Texas documents if you're in Texas. Now, you may have some other questions. For example, a lot of people ask, well, you said to pass around copies, but what do I do with the originals? Well, we want to let whoever is our agent know where to get the originals, where to find them, where do we keep them. In a safe place. The freezer is a perfectly good option. Put it in a plastic bag, stick it in the freezer, Tell your agent, this is where it is. Tell your family members, this is where it is. Don't throw it away thinking it's some rotten piece of meat. Why in the freezer? Because it's fireproof, and in general, it's going to withstand floods. It's going to stay in the same place. Now, I know that there are floods where our freezers float away, but in general, it's a pretty good, safe place. Keep it in your file cabinet where you keep other important documents. Keep it in your underwear drawer. Wherever it's going to be safe, just make sure that your agent knows where to find it. Another question that people often have is, well, how long are they good for? There's no expiration date. You can set an expiration date on the Texas medical power of attorney. You can say this is only good for this period of time. But as I said before, you're going to want to be reviewing them as time goes by and making sure that they still reflect your wishes and updating them as necessary. But if you never have that opportunity, they're good for an indefinite period of time. They're unlimited. One question that you might have is, I'm the medical agent. How do I make decisions for the other person? That goes back to what I was saying before. You need to make the decision that that person would have made. So that means if you're an appointed medical agent by someone, let's say your parent just lets you know, hey, I appointed you, you have to initiate that tough conversation if the parent doesn't, because your job is to do what that person wanted or would have wanted. Let's say that you're still stuck in that place where you just can't get family members to talk about it. Again, I recommend that you turn to current events or recently past events like the Terry Schiavo case and think about and talk to them about, I don't want this to happen in our family. Others who, this is further back, others who never had this conflict in their families were Richard Nixon or Jackie Kennedy. So you can appeal to, don't you want to be cool like Jackie O? I hope that works. I don't think we have any other questions right now, but if you do have questions, click on the Ask balloon at the top of the slide and feel free to go ahead and send that question on. The folks at Learn will send it to me, and then I will answer it as best I can. So even if you're watching this on demand, you can still ask questions. Thank you so much for listening, and I hope that you will follow my advice and go out and do your advanced directives right away.